Tonight on Canton Confidential, answering grave concerns in the courtroom. The relationship between Reed's defense team and key witnesses.
Clearly, the ARCA witnesses were expecting to get paid.
Karen Reed's newest attorney defending what happened during the first trial.
No doubt the invoice was paid. But the story is not solely about was the invoice paid. Facts is it came out of the blue.
Plus, learning about the Commonwealth's new prosecutor from his former legal partner.
Hank is one of the best cross-examiners I've ever seen in my career.
Canton Confidential, the Karen Reed trial starts right now.
And welcome to Canton Confidential. I'm J.C. Monahan. Today, there were hours of legal debate for a high-stakes situation in the Karen Reed murder trial. It could mean key expert witnesses for the defense are removed from the retrial, possible discipline for Karen Reed's lawyers, and today, a new face in Reed's legal team led the charge. Robert Alessi responded to the accusations by prosecutors that led Judge Beverly Cannone, you may remember this, to say she had grave concerns about the defense's behavior. We have team coverage tonight, beginning with NBC 10's John Maroney, who joins us with what was said today inside Norfolk Superior Court.
What the Commonwealth raised does raise serious issues.
Judge Beverly Cannone explaining why she suspended last week's hearing in the Karen Reed case, asking the defense to return and address allegations of improper conduct.
Information that was known to the defense, and for whatever reason, perhaps a strategic advantage, was not provided to the Commonwealth, the court, nor the jury.
The prosecution is trying to keep accident reconstruction experts from ARCA off the stand. In the first trial, they told the jury John O'Keefe's injuries weren't consistent with getting hit by Reed's SUV, raising questions about how he died.
And there is a very unclear relationship, as we stand here right now, between the history of interaction between the defense and these ARCA witnesses.
Special prosecutor Hank Brennan accused the defense of failing to disclose they were getting paid $23,000 and had been collaborating with attorney Alan Jackson.
We've spoken to them only for the purposes of coordination of their testimony and their background.
Attorney Robert Alessi says the $23,000 bill was paid after the trial, but there was no prior financial arrangement. In fact, the defense says it was surprised by the invoice.
There's one person that was more shocked than most about the invoice coming in and the amount.
Let's go. One potential sanction against Karen Reed, the loss of one of her out-of-state lawyers.
No one's going to lose any member of my defense team.
What would that mean?
It would mean an appeal.
This hearing was continued until next week. Judge Cannone telling all the parties involved they could meet on Tuesday, Wednesday, and Friday of next week to deal with all the outstanding motions. In Dedham, John Maroney, NBC 10 Boston.
I'm joined now by NBC 10 legal expert Michael Coyne and, of course, our courtroom insider, Sue O'Connell. All right, Michael, I'm going to start with you because there was a lot of, let's call it, legal jargon today. We're not lawyers, so if you could just boil down, let's start with what Rule 14 is, because that seems to be where this whole begins, this whole thing.
It deals with the discovery and exchange of information between counsel. And your obligations, and the court has made this clear, is for the parties to exchange what's called reciprocal discovery. Provide the information and disclosures to the other side so that they can be properly prepared for trial and to examine the witnesses that the other side is going to produce.
And that's where we're talking about ARCA, if you haven't. So ARCA basically is the reconstruction company that looks at accidents and pedestrian accidents and whatnot, biometrics, whatever it is that's associated with it. So there was a lot of talk about voir dire. Today, we know that's when, I've learned this from you, that you can basically question a potential witness without the jury present. So you can ask questions that maybe wouldn't be allowed in the actual trial, right?
For witnesses, that's what that means.
For
yes.
witnesses, okay, there.
Potential witnesses.
Potential witnesses. And what the defense said today was, this is such an unusual situation. I think the word unusual was used a lot. That the prosecution, all their complaints about they didn't know what ARCA was going to say and the defense knew it, They said there was a voir dire. You could have asked anything you wanted, and you didn't. So that's on the prosecution. Is that what it's for? Is that what they should have done?
No, I find that argument a bit specious. If they don't have the documents, if they don't have the information to properly question the witnesses when they're produced for voir dire, you can't just ask any question out of the blue that might come into your mind. If you had the documents, if you had the information, they could have then inquired about those specific issues with a knowing and intelligent manner of the questioning. Absent the documents, sure, they could have asked any question that popped into their mind, but the disclosures allow us to actually make a decent and reasonable inquiry.
Find your path.
Correct.
Okay, excellent. So we saw some back and forth, Sue, between Cannone and Alessi. We want to listen to a little bit of that, and then we're going to talk on the other side.
My speculation, he sends in the direct to try to get some degree of comfort.
So, with all due respect, please don't speculate. Let's move on to the merits, okay?
I will not.
You can use this maybe at argument at some point, but let's just focus on what we have.
I will do that, Your Honor.
If you know for certain that's the case, that's fine.
I will tell you, and first of all, I appreciate what you said, and I won't speculate anymore. I said I was going to make an exception for this, but here's the fact that I do.
No more, because you said you might do it more than once. So no more speculating. But if you know for a fact that that's true, I'll hear it.
What I am going to do, Your Honor, hopefully productively, with no speculation.
Okay, so you don't have to tell me what you're going to do. Just go ahead and do it.
So I will just go ahead and do it, Your Honor. I first want to thank Your Honor for the generous amount of time you're according to me.
To thank me. Just go right ahead, sir. And take your time, Mr. Alessi. I shouldn't have cut you off. I appreciate that, but take your time. This is important.
Thank you.
Okay, so that went on for hours. The niceties and the not so niceties between the two. You were in court today. It felt a little contentious at times while still being very, professional.
Yeah, I didn't get the vibe from Judge Cannone that she disliked Alessi or wasn't appreciating what he was doing. He was being very thorough. He had a report. He was being very clear where she should look, what he was talking about, directing her. I think so, and again, I don't know her, and I'm just maybe projecting onto her. Some of the exasperation she might have had is just like, oh my gosh, we are going through this process. Can we just get to it? And obviously, you can speak to this, Michael, better than I, not wanting to rob the defense of the opportunity to make their case and to make an argument, but she doesn't need to be convinced in the same way that a jury needs to be convinced,
sure.
Right? So if he's going to be making a statement over and over again, he might be trying to convince a future juror. He might be trying to convince us. And she might just be cutting to the chase saying, I'm a judge. You can tell me what it is. I don't need you to speculate for me. But, again, a few times I saw her, like we did there, pull back and just go, look it. Take your time. Do what you need to do a proper defense here, but we don't need the whole dog and pony show because we're going to be here a lot, and we have been here a lot.
Well, and we know that because it's going to be 3 days next week. I just want to ask you quickly, Michael, do you think what you heard from Alessi today is enough that there wouldn't be punishment for one or more members of the defense team?
No, I don't. I don't think he was convincing to respond to the judge's specific comments about the sidebar representations that were made and about the calling of the witnesses without having any communication with them. It defies logic in that regard, that you would call a witness when someone is on trial for their life and never having communicated with them with respect to that testimony. So I think we got a little deep into the weeds as opposed to addressing the specific issues that Judge Cannone wants addressed with respect to disclosures and misrepresentations.
It felt that way, but not being a lawyer, I wasn't sure.
Well, I'm going to ask Mike.
You play one on TV.
Right? Yeah, I'm going to ask him for some credits for today because because I'm ready to go to law school after this.
Well, it's been a journey, that is for sure. So don't go anywhere. Obviously, a lot more to talk about. But right now, there's so much resting on Judge Cannone. We certainly have talked about her a lot. So we wanted to get some perspective from someone who's actually been in that chair, literally. Jack Lew is a retired judge, once worked in the same court where Judge Cannone now serves, and he spoke to our Michael Rosenfield, who is joining us live. Michael?
Yeah, JC, lots of analysis coming in today, including from a retired judge who knows Judge Cannone and is familiar with some of these issues that she's dealing with. Retired Judge Jack Lew worked here at this courthouse. And part of the 16 years he spent working in the state superior court system in Massachusetts, he says Judge Cannone had to hold the special hearing because everything must be done beyond reproach in case this ends up being appealed down the road to the Massachusetts Supreme Court. Judge Cannone wants to make sure there are no problems. At issue today, allegations, as you heard, that Karen Read's attorneys may have misled the court by not acknowledging that 2 of their expert witnesses were paid. They were presented as independent experts. Their testimony in the first trial was key because they said John O'Keefe's injuries were not consistent with being hit by a car. Judge Lew tells me he doesn't think Read's attorneys will be referred to any investigation into unethical conduct, even if Judge Cannone finds some wrongdoing.
This judge is very careful. I applaud that. And I don't think she would lightly take actions that would result in bar counsel taking actions. But I think she'd be justified in giving somebody a dressing down in court, but a respectful one.
So as you mentioned, this hearing will resume next week, so we'll have to wait and see if there's any potential fallout or repercussions for Karen Read's attorneys. Live in Dedham, Michael Rosenfield, NBC 10 Boston.
Certainly a lot ahead. Michael, thank you. So when we return, we want to talk about the Commonwealth's newest prosecutor. We'll look at Hank Brennan's presentation in court today and talk with one of his former legal partners. Welcome back. The Commonwealth has a new special prosecutor in the Karen Read trial, and we're getting new insight on Hank Brennan from his former legal partner. He spoke with NBC 10's Eli Rosenberg.
The verbal gymnastics that counsel engages in
when the lights shine the brightest
to distort reality is extraordinary.
Like Tuesday's high-stakes hearing in the Karen Read case is when those who know Special Prosecutor Hank Brennan say he brings his best.
Hank is so successful because he's unflappable. Was there an eyewitness? No.
J.W. Carney Jr. has seen a lot during his time as a lawyer, including working with Brennan when both represented James Whitey Bulger more than a decade ago.
Hank is calm. He doesn't yell at people. He doesn't try to trick people. There's almost nothing he overlooks. In Whitey Bulger's case, he had file after file after file for witnesses.
The Bulger trial bringing with it a crush of media.
I'm very proud of our team.
The Read case coming with similar interests.
I know Hank was delighted to handle this case. He had watched it a little bit, like we all did. And so Hank is coming up with ways that he will cross-examine witnesses that will really unravel their stories if they're lying.
But I care that it's unfair, imbalanced, and hidden.
Brennan's attention to detail was on display last week. Brennan using a pretrial motion hearing to call into question the use of accident reconstruction experts by Karen Read's defense.
The Commonwealth just provided the court with information that causes me grave concern,
leading the judge to halt the hearing. It all an example, Carney says, of Brennan's approach to this case and every case he handles.
Hank's attention to detail will be a great help to him during this trial because he will not only have read every document and thought about every document, but responded to defense claims in a very powerful way.
And one more interesting note, you'll of course remember Karen Read's first trial lasted some 9 weeks, prosecutors calling 68 different witnesses. Not so on the prosecution side this second time around. According to Carney, he says Brennan's style is more direct. He only calls the witnesses he needs to help explain and state his case. Live in Dedham, Eli Rosenberg, NBC 10 Boston.
Eli, thank you. We're back with Michael Coyne and Sue O'Connell. Michael, got to see Brennan in court today, a fair amount of him. How did you think he handled today?
I thought he did a great job. I think Jay Carney's right. That's high praise from Caesar, is that he is the dean of the criminal defense bar, and what he saw and his colleague Hank Brennan, we all saw it today. I think he handled himself effectively. He handled the case well. He didn't use too much of the court's time to make his points, but his points, I think, were very strong and consistent with what the judge wanted to examine as part of this hearing, is the focus on the misrepresentations, focus on the sidebar conferences, and focus on whether Rule 14 was, in fact, followed with respect to those disclosures. So I think he did a terrific job representing the people of the Commonwealth.
I would say, though, JC, though, yeah, meticulous. But remember, in that hearing, he got some information wrong. He thought that the discovery was sent by the federal government, by the feds, when it was actually sent by the defense.
Right.
And to the point, though, there is a mountain of information that both he and Alessi and anybody else have to catch up on. So he made a crucial mistake in that hearing, which they tried to really bring home, that, you know, we gave you the discovery and you said you didn't get it. And that, I don't know that that dog's going to hunt very far.
But the difference is that he immediately corrected the mistake and misrepresentation he made to the court, where that was never done with respect to the defendant's representations to the court until the 13th of February of this year. What is that, 6, 7, 8 months after the case was tried?
That's what I remember Brennan sort of wrapping that up with. Hey, you know, we said we made a mistake, and they're not saying they've made any mistakes. That's sort of. All right, we have so many more questions for you. Don't go away. Still to come, the federal investigation into the death of John O'Keefe has ended with nobody charged. So how could that impact the state's case against Karen Read? We dig into it when Canton Confidential returns. We are back with Michael and Sue. One thing we learned yesterday from NBC 10 Boston sources is that the federal investigation into the death of John O'Keefe has ended with nobody charged. So how does that get broached or used in the second trial?
I think what is likely going to happen is they'll treat it the same way as the first trial, is that it really isn't relevant that whether the government charges or doesn't charge as a result of their investigation. It's not relevant to this case simply because at best it's an allegation. Now it's a non-allegation. It doesn't say something didn't happen. It says that they didn't find any evidence that would support criminal activity that they could charge.
Just to remind everybody, this is the federal investigation into the investigation. So it really is separate from the case itself. Sue, I wanted to bring you in on this point. Alessi was pointing out that when Cannone stopped last week's hearings, she said she has grave concerns, and the prosecution stood up and made all these allegations without an official affidavit or a motion or anything. He thinks that that has sort of tainted the jury pool, made it biased. Let's listen to a little bit of that. We'll talk about it.
And I'm not saying this for drama's sake. I'm saying this for what has impacted the defense 6 weeks before trial starts while jury notices are out in the mail. Those words, based upon the misdirections that your court had to endure, have gone through, and I'll just name a few headlines in the Globe, the Herald, every TV outlet, social media exploded. And these are not trivial issues. And more than that, the veracity of counsel has been called into question. There's commentary of everybody about what's going to happen to certain members of the counsel's team, and whether it's intended or collateral damage. We've got the ARCA experts, which are key parts of our case. Their credibility is being pillared throughout the public domain. And this could have been avoided.
2 words, grave concern, and apparently we've had a media storm. Is that right?
So, yeah, so the Karen Read defense team being upset that there might be things leaked out that social media might have a storm about, or that people might jump to conclusions about, or people might pick a side about before a jury has been picked, or a jury has deliberated, or a jury has delivered a verdict is a little rich. But this is what lawyers are supposed to do, right? This is the job they do, regardless of what their team has done in the past. And I'll note, there were no affidavits today either on either side. The defense could have come in with affidavits. They could have come in and said, look, we took all this time, we did this great report, we've got it, and here's the evidence and a sworn affidavit saying this is what happened. So, you know, the one thing I love that I learned about this case is that you always hate the lawyer that's on the other side, right? But if that lawyer did a good job, you would hire them in a heartbeat if you needed them. So He's just doing what he's supposed to do. But it is rich to be accusing, of beating the bushes a little bit and poisoning the well when we've seen a lot of that going on.
Everybody hates lawyers until they need us.
One, right.
Well, that's the truth. Always has been, but we love Michael. Stay right there. We'll be right back. Karen Read's retrial is set to begin April 1st. We will stream it on our sister station, NECN, along with all of our streaming platforms. You just search Boston News on any of your apps. We will be taking you inside that courtroom every day. And of course, we will have new episodes of Canton Confidential right here at 7 o'clock on NBC 10 Boston. But what's most important right now is the focus for the reason for all of these proceedings, all of this time in court, finding justice for John O'Keefe, giving his family, along with the city of Canton, closure. We hope you all have a good night.